Hey y'all! Today we're unlocking the mysteries of probate in Texas. If you've ever wondered about the intricacies of transferring an estate in the Lone Star State, you're in the right place. Stick around as we demystify the probate process step by step. But before we dive in, I have a quick story about why probate is so important. Probate ensures that the estate is properly transferred to the heirs per the decedent's wishes in the will. In my prior career as a landman, I often dealt with a lot of people that didn't ever go through the probate process. There was a will, and they thought they owned what the will said. But not probating the will ends up creating quite a stir whenever it comes to your ownership of both land and minerals. And so it's very important to probate because oftentimes if someone gets cut out of the will, they may end up with a portion of your interest because you did not probate that will. And make sure you probate the will or provide an affidavit of the probate proceedings for the will in all of the counties in which there is real property. Probate in Texas. It's a legal journey that can take a few twists. Let's start with the basics. Probate is the process of administering a deceased person's estate. Now, there are two scenarios that could unfold: testate and intestate. A testate scenario is that there is a will. The executor named in the will plays a pivotal role in executing the deceased person's wishes. On the flip side, intestate means no will. In this case, state laws step in to guide the asset distribution among heirs. Now, let's talk about the timeline. Probate proceedings in Texas usually span several months to a year. It kicks off with filing the will and appointing the executor or administrator. This marks the beginning of the 4-year statute of limitations for contesting a will. The executor receives Letters Testamentary. This is the golden ticket granting them authority. Soon after, the notice to creditors goes public, giving potential creditors the chance to make their claims. Meanwhile, the executor compiles a detailed inventory of the deceased's assets, providing a snapshot of the estate's value. Now, about administration. Texas offers two routes: independent and dependent. Independent administration, if permitted by the will, allows for a streamlined process with fewer court interventions. In contrast, dependent administration involves more court oversight. As the months roll on, the executor works through resolving creditor claims, filing tax returns, and ultimately distributing assets to the heirs. Their final step involves closing the estate, marked by a court order declaring the process complete. Phew, that is going to be a whirlwind. But remember, each case is unique. I'm not an attorney, and none of what I have said should be construed as legal advice. Seeking legal advice from a licensed attorney is crucial. If you are interested in downloading my free PDF for the duties and responsibilities of an executor, click the link in the description below. Also, if you found this information has been helpful, please give it a big thumbs up and share it with anyone navigating the probate journey. But wait, there's more! In the next video, we'll delve into if you have to pay capital gains tax on inherited properties. You won't want to miss it, so make sure that you're subscribed. As we wrap up today, I hope this journey through the probate process in Texas has shed some light on the path ahead. If you have questions or specific topics you'd like us to cover, drop them in the comments below. Until next time, this is Erica Parker, your certified probate real estate specialist, signing off. Bye for now.